Hello again, it's Professor Kristl, and this is part 2 of our video number 4. We've been talking about legal analysis, so we've been talking in terms of there being 3 basic components to it. The ability to work with the law, the ability to work with facts, and the ability to communicate. That's the essence of legal analysis. Okay, well, how do we do that in law school? Let's talk first about how we teach it in law school, how we're trying to get you to learn those skills in the way we conduct our classes in law school. And we can think first in terms of how we teach working with the law. Well, there's a couple of different things that we do. First, you need to develop what I call a storehouse of knowledge. The collection of various legal concepts that allow you to hear a set of facts from your client and to be able to say, oh, that's a contract problem. Oh, that's a tort problem. The ability to sort out. Look, when you came to law school, you didn't know much, if anything, about torts or about property. Certainly, you probably knew nothing about civil procedure. So you have to learn those things. In order to be able to recognize what area of the law is involved, you got to have some sense of what's involved in those areas, right? So learning rules, learning the things that you will learn in all your classes in law school, help you to build up a set of knowledge that allows you to compare facts against or compare a story against and to say, you know what, I think I need to focus on this particular area because that's what this sounds like. All right? So building that storehouse of knowledge, that's an essential part of what we do in law school all the time. All right? But just as importantly, we work on some of those other skills. You know, we talk about the ability to find and figure out the specific area of the law. Well, we develop some of those finding skills in law school. For example, every time we read a case and we say, well, what's the rule? We try to figure out that. That's a skill that you have to be able to use when you're out there in practice because you're going to read cases and you're going to have to figure out what's the rule in this case and does it apply? How does it apply? So those are important skills you have to learn. And obviously in legal methods, you're going to learn how to go out and research the law, to find the cases around a particular question so that you can answer, right? So we teach you finding skills because you're going to need to know that and use that when you're out in practice. We also teach you applying skills. You know, you have to apply the law when you're trying to answer an in-class hypothetical, right? You get a different set of facts. All right, well, if that's what the law is, given these facts, how do I apply it, right? A practice problem that we have after class, or a quiz, right? You got a set of facts, you got to figure out what's the relevant area of the law. This sounds like a bailment question. And then what's the specific rule, and is that rule being satisfied? All right? Applying in those quizzes or practice problems, right? Doing practice tests, same way. And in your legal methods class, you know, you're going to write an open memo, you're going to write a closed memo, you're going to work on the ability to take a certain set of rules given to you by the case law that you've found or been given and apply it to a set of facts to be able to reach a conclusion about what's the likely result for this particular client problem. Right? So you're learning those applying skills in both your substantive classes but also, very importantly, in your legal methods class. All right. Well, that's working with the law. How about working with facts or your communication skills? Well, facts, you know, we obviously, when we read our cases for class, we're trying to pick out the facts. What's important? What did the court focus on? You know, what shows that the rule is or is not satisfied? Same thing we get, too, with when we do hypos, right? Because every time we do a hypothetical in class, we're taking a different set of facts and trying to see, does the rule apply or does it not apply? And if so, why or why not, right? And obviously when you do practice problems or you do quizzes, right, you are, in effect, working with the facts of the particular problem and the rule that applies and then putting them together to come to a conclusion. How about your communication skills? Well, speaking in class is one of the most obvious ways that you work on your communication skills. The ability to articulate what your question is in terms of the legal concepts that are involved or the facts that matter. You know, that's an important part of your ability to communicate. Right? you are going to work a lot on your communication skills in legal methods class. So you've got to, communicate your analysis and your conclusions in an effective way. And that's what legal methods class is teaching you how to do. And obviously when you're writing a paper for a class or you're writing an essay on an exam, you are communicating your legal analysis. And so those are all opportunities in the law school context for you to work on and learn and improve those skills. Okay, well that's the theory, okay? How do we make legal analysis work for us in law school? How can we learn, and what is the expectation for legal analysis in law school? Let me tell you what my expectation is. Right? Other professors may have slightly different expectations, and the most important thing is for you to figure out what your particular professor wants. Right? But this is what I sort of expect from your legal analysis in law school, because I think that this mirrors closely what you have to do in practice. Right? So, first, what do you need to be able to do? Well, you need to be able to recognize the rule in play. Remember, we talked about working with the law as recognizing the general area, right? Is this a landlord-tenant question? Is this an adverse possession question? Is this a found property question, right? Recognize the general area, but then recognize the specific rule that you want to focus on, right? So, can you do that? And I see that by whether or not you're picking the right multiple choice answer, but I also see it especially in essays or short answers, where have you recognized the right area and the rule? Then, secondly, is the rule being satisfied? Are all the elements present? Are there exceptions? Do they apply? Do they not apply? All right? Is the rule being satisfied? And just as importantly, why or why not? Okay? A lot of times, a rule is not satisfied because some element is missing or because some exception applies. Right? But the ability to identify why it is or why it is not is essential. And then having done all that analysis, it's the ability to explain how you applied the rule in this context. Right? And from my perspective, that means showing the thought process that leads you to the conclusion that you reached. And when I say showing the thought process, I mean showing all the steps. Okay? If you write an essay answer which says, yep, there's a bailment, looks like it's satisfied, that's not very effective legal analysis. It may, purely by chance, purely by luck, get the right answer. Okay? But that doesn't tell me that you know and that you got to the right answer by applying the appropriate rules in the appropriate way. Okay? By showing every step. This appears to be a bailment. There are 4 elements in order to be able to have a prima facie case of bailment. A, B, C, and D. And now we can see that given these facts, A is satisfied, and B is satisfied because this, and C is satisfied, but D is not satisfied. Right? And using the facts to explain how the elements are or are not present. Right? Now, in some classes, professors want you to do something more along the lines of, tell me what the arguments are on both sides. Right? What will be the arguments as to why this is a bailment, why it's all satisfied? Tell me the arguments why it is not a bailment. Right? And some people, say, well, that's sort of cynical because that's teaching us, not to take a position, not to have a conclusion we can argue whatever side we want. No, that's not the reason why we do that. In law school, we do that because your ability to articulate both sides of a particular argument can help you make a better argument for the side you're advocating. Look, I find that if I stop and think about what will the other side argue in a clinic matter, that by articulating it, I can see, A, what are the weaknesses in my argument, I better shore them up, or B, here's how I'm going to respond to it. Here's how I'm going to defeat their arguments. I might not figure that out if I don't stop and think, well, what are they going to argue? Right? So the ability to argue both sides doesn't mean we're amoral. It means that we have the ability to be thorough and then using what we know about what the other side's going to argue, develop the best possible arguments for the side we want to argue. All right? So find out what your professor wants. Do they want both sides being argued? For me, I just want to see your analysis that gets you through the rule and applying the facts to all parts of the rule to figure out what your conclusion is. And to me, it's a lot more important that I see that complete analysis than it is that you reach some conclusion that I might reach given these facts. Okay? So it might be less important in an essay that you find, yes, that was this kind of found property, or, it's mislaid versus lost. All right? And so the fact that you did the analysis, that you can defend the analysis in your presentation really helps to maximize your points and to show me that you really do know how to do thorough, complete legal analysis. All right? Look, when you're in law school, take advantage of the opportunities. All right? You can become better at this if you are actively engaged in class, if you are answering the questions that are being asked in your head, if you are challenging yourself to think about what are the different ways to analyze this as you look at a particular case as you're preparing for class. That you practice with practice tests or practice quizzes or other materials so that you get better at the skill by doing it again and again and again. All right? And take your legal methods class very seriously, because in legal methods you are learning these critical skills. You want to be a successful lawyer, you need to be a good legal analyzer. And legal methods helps you get there. Don't think that, well, maybe it's fewer credits or whatever, I can give it less attention. No. It's very critical to your law school success and your success as a lawyer that you take legal methods seriously, because it will pay you benefits. It will pay you dividends. Trust me on that. Look, the bottom line is that, legal methods and our law school experience really tells us the following. Legal analysis is a skill. It's not a natural born talent, it's a skill. And so what we need to be able to do is to practice it, because the more we do it, the better we get at it. You can't take shortcuts to becoming a good legal analysis person, okay? And you will always get better at it if you work at it. I know that after 30 years, my ability to analyze legal problems is better now than it was 2 years ago, 5 years ago, 10 years ago, and certainly when I came out of law school, all right? Because I'm constantly learning new things, increasing the storehouse of knowledge, but learning new things that allows me to be able to do better legal analysis. All right? You got to work at this, but you can do it by taking seriously class participation, taking seriously legal methods, working hard, and you can become a good legal analyzer, and therefore a good student and a successful lawyer.